Legally Speaking with me, Tarun Nangia. A very, very important show. It is on the 150 days of Justice Dhananjay Chandrachud as the Chief Justice of India. You were all part of a series which we did when Justice Chandrachud was to take over as the Chief Justice of India, and we had titled that series as Hope. And a lot of those hopes have come true. In the sense, we've got a Chief Justice who speaks his mind. We also saw the decision on the bail matters to be listed. A very pro-liberty judge. But I think it is for my panelists to do all the talking and what has been done. They are the experts. They go to the court of law every day and the Supreme Court. Let me introduce to you Senior Advocate Saurabh Kirpal, a well-known commercial advocate. He practices at the Supreme Court of India, the Delhi High Court, and other forums also. I have with me Senior Advocate Percival Bilimoria, who also practices on commercial law at the Supreme Court, the Delhi High Court, and other forums, also financial crimes involving the Enforcement Directorate, which is PMLA, and other issues. Good to see you too. I have with me Advocate Abhimanyu Bhandari, also practicing at the Supreme Court of India, the Delhi High Court, also doing a lot of financial crime cases involving ED, PMLA, and others. Good to see you too, Abhimanyu. At the outset, I want to request Senior Advocate Saurabh Kirpal that in the first 3 to 4 minutes, if he could set the tone of the show by talking about what he has seen Justice Chandrachud accomplishing in these 150 days, since he's seen him as the Chief Justice of India. Over to you, Mr. Kirpal.
Thanks for having me on your show, Tarun. I think the one thing that Justice Chandrachud has always wanted to do and is obviously now on the path of accomplishing is to move the court closer to the citizen. I think that has been something dear in his heart. He wants to make it an accessible court. He wants to make it a court that is examined. He wants judges to understand what the lives of the citizens are, and therefore their issues, priorities, and interests are placed front and center in everything he decides. Now, I'll give you just 2 examples, one on the administrative side and one on the judicial side. So on the administrative side, for instance, he has decided that he will ask for translation of judgments in the vernacular. So judgments are written in English. Now, a very small number of people in our country speak English. This is automatically exclusionary. So people who otherwise interact with other organs of the state, the executive or parliament or the legislature, they speak in their vernacular language, and there's an understanding and an engagement and a debate with those branches of the state. But the judiciary has been noticeably absent, at least the Supreme Court, on this front, because the judgments are written in a language that are completely inaccessible to the vast majority of the people. So this act of translation of the judgments in the vernacular will really engage and inform the citizen about what is it that the Supreme Court does and what are the kind of decisions they take. This will also have the salutary impact, of course, of ensuring that we have a more legally literate population. One of the problems, I think, which Justice Chandrachud has to overcome is the absence of legal literacy and the inability of people to go to courts of law and get their rights. So I think that is a great reform on the administrative side that he's taken, which will play out in the future years. And the second, I think, in the same light, really the kind of cases that he's taking up for hearing. I think matters relating to liberty and matters concerning individual fundamental rights of citizens. I'm sure as we go on in your show, we will discuss them, what these are. These matters are being taken out of priority. And even though I am a commercial lawyer, and sometimes you think that only commercial matters should be heard first, and we go to court and insist as senior counsel, no, this is a very important matter, hear it. But really, other than the 2 parties to a commercial dispute, that decision and the time that is spent on that decision has very little impact on the vast majority of the people of the country. So by prioritizing issues that relate to citizenry, I think that is another way that the Chief Justice is seeking to bring the court closer to the heart of the common citizen. And that is its constitutional goal. That is the idea when the framers of the Constitution made the Supreme Court, gave it Article 32 powers, gave it Article 142 powers, which is right to approach the Supreme Court. The power to the Supreme Court to pass directions uninfluenced by really any constraints of law. The idea is that the Supreme Court is the ultimate guardian of the citizen of India. And it is Chief Justice Chandrachud who is taking us back to the constitutionally envisaged role of that.
Okay. Thank you. Thank you so much, Mr. Kirpal, for that setting the tone of the show. I'll go across to Senior Advocate Percival Villimoria. I remember you talking about a dog matter that you were taking up in the Supreme Court and how passionately you spoke about that, Mr. Villimoria. And I was wondering, a lawyer which day in and day out does hardcore commercial cases involving businessmen can also equally speak on issues related to animal rights also. Can you also speak on both commercial as well as the other issues and Justice Dhananjay Chandrachud's 150 days?
So look, I think, one of the reasons why we are even having this podcast is that the CJI has shown that he is both courageous and progressive. I think Saurabh touched upon that briefly, and he is clearly setting the agenda. So another example I can think of inclusionary practices is that he's trying to push paperless courts and encourage VCs. Now, again, here, there is a small distinction between a paperless court and a VC. VC is the mode of submission before a court, but you can have paperless courts all the time. The idea of having a VC is ultimately to ensure that people in remote places also have access. Their lawyers can appear in their matters before the Supreme Court without having to travel all the way here. And it is a convenience. But the initiative to encourage paperless courts is something which needs to be commended. Again, in terms of the issues that he has picked up, I agree with Saurabh. For example, he has struck the right note on press freedom. So while ensuring that the Supreme Court is very clear on the fact that you cannot gag the press, and that's absolutely non-negotiable, he has also said that media trials are not really, it's something to be frowned upon. And also, he has laid down the clear law that quite apart from the fact that the press has an important role to play, the press should be mindful of the duty it has to report the truth. It cannot misreport. And because that can, play havoc with civil society. If the media misreports or the media has a slant towards one political party or ideology or the other, that's not good. So I think that is another principle that he has spelled out. On constitutional rights, as we speak, we know that we are keenly following one of the decisions that is before the Supreme Court. And, I'm sure it will come to the right conclusion on this one too. On the commercial side, also there have been a few matters that have been taken up. So in arbitration, for example, there is the concept of whether, because arbitration is a private consensual process. So the question that arises is that sometimes can you split the cause of action and can you rope in non-signatories to an arbitration agreement? And we had a decision of chloro controls and other decisions flowing after that. And that issue has now been taken up, and the Supreme Court is about to pronounce on this. The orders are reserved, so I'm again keenly awaiting, that decision. I'm sure, Saurabh and Abhimanyu are also looking keenly at that one. So overall, I think an excellent tenure so far and much to look forward to. On constitutional rights, let me tell you, I'm also involved in a matter regarding Parsi women's rights. Because the rights of Parsi women who marry outside the community are severely curtailed, and more so that of their progeny. And this is based on a 1908 decision, which is, we should have gone according to the doctrine of eclipse. But it is still followed very much as law. And that's a matter which I've taken up before the Supreme Court for one lady in Bombay.
Point well taken. Thank you for your opening comment. I'll go to Advocate Abhimanyu Bhandari. Mr. Bhandari, you have a very pro-liberty approach in many cases. I remember doing the PMLA series and how passionately you spoke about keeping businessmen out of jail and how it impacts businesses, loans, livelihoods. I want to go into that aspect. Justice Chandrachud has taken a very, very pro-liberty stand. So many bails have come after he took as Chief Justice of India. Could you go into that aspect also while you speak?
Sure, I will. But Tarun, before I launch into that aspect, and I've heard Senior Advocate Mr. Kirpal and Senior Advocate Mr. Bilimoria, and I think I'm not going to repeat the comments that they've made. I totally agree with both of them, every comment that they've made. I want to talk a bit about the practical impact of the Chief Justice. I think one of the toughest things for a Chief Justice when he's sitting on the judicial side is how he is handling the mentioning board in Supreme Court. Whether a Chief Justice is popular, not popular, how the bar perceives that Chief Justice, a lot depends on how the Chief Justice handles the mentioning board. Now, let me explain to you, for your viewers, what I mean by the mentioning board. What happens is that there are a lot of matters in the Supreme Court. There are a limited number of judges. Everybody wants their matter heard. Someone wants an urgent relief. Someone may have lost a case in the High Court and he needs to come to Supreme Court and get some kind of an urgent relief. For example, a bulldozer might be coming to destroy his house, or he might like to get anticipatory bail where he wants to be heard immediately so that the police doesn't arrest him. So we have to many times go to the court and request the court that please take up my matter for hearing. This aspect of Supreme Court has always been something I think it's been quite difficult for any Chief Justice to handle, because there are long queues of lawyers waiting to mention their matters. There is a lot of pressure to list everyone's matter and have everybody a day in the court. Now, let me tell you this. The way this mentioning board has been handled is absolutely brilliant, Tarun. There were times, and I've been practicing in Supreme Court for now more than since 2000, and I started way back. And let me tell you, many times I've seen that a lot of young lawyers used to feel that if they go and mention their matter, the chances of them getting a relief that it should be heard would be much lesser. And if a big senior counsel goes there and mentions, then, the chances of getting that matter is much more. That myth has been completely shattered this time. Lawyers all are getting an opportunity to mention. The system is so good that you go and put forward your pro forma for mentioning, it's taken up, you're heard, and if there is an urgency, genuine urgency, then the matter is dealt with, it is listed immediately. And therefore, among all members of the bar, there is complete equanimity that, yes, if something is working properly, it is this whole mentioning, because that causes a lot of stress among lawyers if they can't get their matter even listed or heard. So therefore, I think, every day, the Honorable Chief Justice is spending huge amounts of time in the morning, listening to lawyers from all around the country, people coming physically, people appearing on VC, and listening to their request and making a decision whether it should be listed or not listed. And it makes no difference, Tarun, and I'm telling you, it makes no difference whether you take a big senior advocate or you take a junior lawyer, as long as that lawyer can put forward what is the urgency and the genuineness of the urgency, that person is getting relief. And this is absolutely groundbreaking, because if you can handle this aspect of the judicial side, because the mentioning is the prerogative of the Chief Justice, you can only mention before his court. That's the rule he's the master of the rolls. And this has always caused trouble to a lot of erstwhile Chief Justices. I know we've seen situations where there were times when some Chief Justices used to never allow people to mention and say, go to the registrar's court to mention. That caused a lot of anguish and grievance amongst lawyers. But the way this court has handled this whole mentioning board has has de-stressed a lot of us at the bar. And we all feel confident that tomorrow, if you have a genuine case which needs to be heard, we can go and we can mention it. Now, Tarun, this is an indication. A long time back in LinkedIn, I was once reading, and I was not a part of that conference, but I was reading on social media that Justice Rohington Nariman had said that when Justice Chandrachud takes over, it's going to be the golden era of our judiciary. And let me tell you, Tarun, we all feel that we are now going through a golden era, not only because of the great Chief Justice we have, but very well supported by the other members of his collegium. The top 3 judges, along with the Chief Justice, it is absolutely a phenomenal time at the Supreme Court. And it is a time where every lawyer feels he's being heard. See, as lawyers, Tarun, when we go to court, we'll lose our cases, we'll win our cases. If there's merit, we get justice. We win, we lose. That's not in our hand. But we don't come out of the court feeling injured. We feel we've been heard. We've been able to make our point. That's important, Tarun. And that is what is happening in the Supreme Court now. And one feels that however powerful and mighty the government might be or the state might be, and however powerful a lawyer on the other side might be, if you have a good case, you're getting relief. And that is the goodwill that is spreading all over the country. So I think along with the Chief Justice, we should also kind of appreciate that he has an excellent collegium supporting him in taking initiatives. Now, please see the whole virtual, the VC, online VC system that has been brought in. After COVID, many people thought, COVID is over, people are back to their normal lives, so VC will go away. No, VC is there. And what is good about VC, Tarun? We have one Supreme Court. That Supreme Court is the Supreme Court for every part of the country. So any lawyer from anywhere today can log in and be heard. And the good thing is, when a lawyer logs in and is heard, he doesn't feel that because he's geographically not in the court or physically he's not in the court, he's not getting a hearing, or that he could have been made a better impact if he was there physically. No. So therefore, a lot of litigants are now using their lawyers in different parts of the country, which also allows a lot of lawyers who would probably never get the opportunity to come and put forward their arguments for their clients, who they've worked for many years and they know the matter better than they would brief a person overnight, to participate in the judicial process and the adjudicatory process and to make their point. And they are being heard. It's not a namesake virtual system where there is a virtual set, but actually no one is logging in and no one feels that it is worth the while. Like, you have to actually come. Litigants are okay. I see a lot of litigants saying, okay, if you're doing it virtually, well enough. And that's very good. And what is good is there is no such system that, a old school boy, that kind of a thing, where you have to go with a particular lawyer or you have to go with a particular set of lawyers you have to pick up to go and make your case. No. Anyone from any part of the country who can put forward his argument eloquently today is going and arguing his case. So therefore, there is a completely different hope that we see in the Supreme Court, where lawyers who may not be senior advocates, junior lawyers, are getting an opportunity to argue, make their case, whether it is to mention to get their cases listed or to argue a very important liberty matter for any client. Now, coming to the liberty issue that you mentioned, Tarun, I think the emphasis that the whole Supreme Court has given to liberty is phenomenal. We were very concerned that liberty is a very important part of our democracy. And we are seeing, and as you remember in your last show, Tarun, when we discussed that how bail matters are getting priority and are getting listed, how anticipatory bail matters can be mentioned and can be listed. Therefore, no litigant would feel that he didn't get an opportunity to save himself from arrest. And if he had merit in his case, the Supreme Court did not hear him. No one would feel that today. Today, if you file an anticipatory bail, all you have to go is do it, mention it, and it will get listed, it will be heard within a short period of time. And this change brings in a lot of confidence among litigants and among lawyers. So I think it is a great time that we are having at the Supreme Court. I think it's a time when we are seeing that lawyers from around all parts of the country are being able to participate. And everybody's feeling whether they win or lose is not in our hands, Tarun. And of course, the judges have to do what is right. But every lawyer is feeling that they are being heard. Lastly, Tarun, away from the judicial side and the judicial work, I think another great achievement of the Supreme Court recently has been in the last 150 days is that the Honorable Chief Justice is making a point in his press comments or when he's speaking in conferences or by his actions that, look, lawyers of different backgrounds, you don't have to go to a particular law school to get a law clerkship. You don't have to belong to a particular family to be given a law clerkship. You don't have to be in the system. You can be a complete outsider with no connections in Delhi, with no connections in any capital city, with no uncles and aunties in the profession or uncles and aunties in the government, but you can still aspire to get a law clerkship. You can still aspire to come to court and you can argue. And I think that the way the Chief Justice is portraying that, he's allowing a lot of young lawyers to come up and have hope that they can also aspire to be great lawyers one day. And there is this positivity that is coming up. I go to Supreme Court almost every day. And now I see a lot of young lawyers who would never come to Supreme Court are coming, engaging other senior lawyers, participating and speaking positively. I see lawyers with no background whatsoever, with no connections, no VVIP connections, no daddies and uncles sitting here there, coming and getting law clerkships in Supreme Court. And what is the impact of this? The way Supreme Court talks and walks is what then other high courts do. So this is not only having an impact as far as Supreme Court is concerned, but with the stand that Supreme Court has taken, other high courts are opening up. Lawyers talk to me. I work with certain charities where lawyers, from very vulnerable situations are getting legal education. They say that it's become so easy and they don't feel today that, I don't know X, so I'm not going to get a job as a law clerk, or I'm not going to get an internship with a senior. And this is having a positive impact in the entire bar. Today, we are having the bar itself is now understanding with the stand that the Honorable Chief Justice has taken that no, we need to follow him and we need to give opportunities and we need to create a system of equal opportunities and allow people from different backgrounds to come and participate in this in litigation.
Thank you for bringing in a range of points from the judicial, administrative, and other issues also which you raised, speaking so passionately on the subject. With this, we draw to a close of part one. We begin the part two of our discussion, and we'll begin with Senior Advocate Saurabh Kirpal on this one. You've seen Justice Chandrachud's decisions on the administrative side, on the judicial side. What is the central theme that you see in all his utterances? See, we have a very vocal Chief Justice. He delivers judgments inside court, but when he's addressing an audience, and a lot of people are known for their intellectual prowess. They talk things which many around them don't understand. You have to have a certain intellectual capability, a certain mind, a certain reading, ideas which people may be understanding maybe 10 years from now. Look at his utterances on the cases that are now before the Supreme Court. The themes that he is talking of, many people simply don't even get it, just goes through them. What he utters goes through them. They have to read again and again, maybe to get what he means. So on the intellectual aspect also, if you could reflect on what Justice Chandrachud is, of course, all his decisions on bail, of course, his decisions on the fraud circular, which I think we will discuss on this show. Big, great commercial judgment, Rajesh Agarwal. But also on this, if you could reflect on these aspects.
Well, I think you've kind of captured two very important aspects of Justice Chandrachud's thinking. One is his empathy, and the second is his erudition. And I think that really the two of them combined together to give him his fearlessness. I really think it is the three of these, the two earlier, which give rise to the fact that he can go and in every fora, be it either in debate in law schools, and sometimes we are used to judges just doing that and not giving in their judgments, but also then carrying that forward, that view, that philosophy in the judgments and comments made in court. That fearlessness that he has exhibited is not just in the occasional interview that is publicized by some news channel. The fearlessness that is done is indicated in the judgments that he has delivered. You mentioned the fraud circular judgment. And again, that's something that has vexed high courts across the country for such a long time. It took him no time to really strike down the RBI circular and say, have a natural justice. And again, we can come back to it. That does take a certain amount of courage because you are then interfering with economic policy of the RBI. But because you say, ultimately, I am the person who is in charge. It is the courts which will ultimately determine as to the validity and the correctness. And this idea of the pushback, this fearlessness that it is the court's role as a guardian has come in many other cases. So, for instance, in the idea that you can't have a sealed cover procedure. Increasingly, government was resorting to sealed cover and giving those documents. So it's now come out with a procedure saying that you can't just give a sealed cover document and completely inconvenience or put one side to a case beyond all knowledge of what the case against them is. And that also shows fearlessness. Similarly, how he deals with national security issues, saying that lip service and just pleading national security as a mantra is not sufficient. Because government, I think, had gotten used to it, getting a free pass by mentioning this magical phrase of national security and doing nothing about it. He has put a stop to that, saying that when you mention national security, we expect you to show how national security is affected. So this shows a fearlessness. And that, as I said earlier, comes from his empathy and his erudition. Now, the empathy part of it is very clear. I think you have to read only some of his earlier judgments. Navtej Johar, I know Deepika versus CAT, where he has always stood up for the rights of the disadvantaged, for the rights of the least vocal. He is giving a voice to those who are voiceless. And that can only happen when he puts himself in the shoes of the most disadvantaged person and walks in them. He is not here to represent the interests of the majority or those who can take care of themselves. That is not the role of the court either. The idea of the court, the healing touch, the balm that the court provides, is for those people who need the help of the Constitution. And that is exactly what he is doing. He is helping those who the Constitution envisaged needed help. The minorities of our country. Minorities not just in terms of religions, but even those who have little access to justice. So he's helping all of these. All of this forms kind of a spider's web. The video conferencing that Abhimanyu was talking about ultimately allows the poorest person to access justice by coming to the Supreme Court through video conferencing. So this is all part of his empathy and understanding. How is it that the poorest, weakest, most marginalized and oppressed sections of society can be assisted and helped? But this is not just a person who is some neo-leftist without any intellectual heft. This idea of his comes, of course, from the constitutional scheme. So it is very well grounded, these views. But he's also an extremely erudite man. So when you read his judgments, I think anyone who argued before him and then reads the judgment thereafter, you come away slightly ashamed, thinking that I had cited only 5 judgments and 3 articles, and here comes this judgment, which is so well researched, has 10 times the number of judgments that were cited, that many more articles. The application of mind, the clarity of thought that comes in a judgment is one aspect that a judge is supposed to have. Most judges do have, and certainly Justice Chandrachud has that in more than abundance. But that clarity of thought is not sufficient. That clarity of thought has to be fed by a variety of knowledge, varieties of sources of knowledge. And that is something Justice Chandrachud is very good at. He doesn't restrict himself just to precedent, which of course he is excellent at marshalling. He takes international and foreign jurisprudence. He will take a lot of articles authored by legal academics across the world and in India. But more than that, he will also take other pieces of literature which inform his writing. You know, ultimately, Tarun, we are lawyers and judges, and what will last beyond our lifetime will be the words that we write, the words that we pen, the words that we speak. Our tools are words, right? And for that, we must understand that drawing on sources which also have words as their tools is not a bad thing. It's a happy companionship. So when you look at a book and use a quote or an anecdote which is there in the book, for instance, in Navtej Johar, which is the 377 case, Justice Chandrachud quotes of all people Leonard Cohen, the famous singer, and quotes his In the Ashes of the Gay, a poem written by Leonard Cohen. And that informs the judgment. It is not something which is a mere embellishment. It is not something that is tacked on with a view to showing, look how intelligent I am. That is not his intention, and that is not what any of this does. Each of these sources adds to the complexity and deeper understanding of the issue that he is dealing with and gives it that heft and meaning, a heft and meaning that will go beyond the time of just our case today, but will speak to the future. The Supreme Court being a court of record speaks to not just the courts today, not just to the high courts, everything today, but it speaks to a future intelligence. And that is what I think Justice Chandrachud is bringing to the table.
In fact, what Justice Chandrachud makes us realize that being a judge is much more responsibility on a person, in the sense that you are laying down law, in a sense, for a country of 145 crore people. Laws, for example, beautifully encapsulated in the Rajesh Agarwal judgment, and then the hearing on gay marriages, two different spectrums altogether. Hardcore commercial case, where he said the constitution will rights will override any policy decision of the RBI, right to be heard. That was, in a sense, he made us understand through the judgment that a businessman can't be declared fraud. You have a right to be heard. And so beautifully, and before I go to Mr. Percival Birimoria, I remember a huge discussion on patriarchy that I was part of about 4 or 5 years ago. And one of the panelists told me that, no, Tarun, patriarchy has cast a huge burden on our men, because there can be men with feminine tendencies and women with masculine tendencies. And what happens is men have been taught with things, you can't cry, you have to behave in a certain manner. So men are being crushed by this society, where they say men are actually dominating because the society is patriarchal, but not understanding what kind of burden even men goes through. But when you see him talking of all this, you realize the man also talks commercial judgments with equal sense as he talks about other aspects of life. And it is truly a revelation that he can be as good with commercial issues as with the personal and family issues.
I'm not going to.
You have to say something.
Yeah, I'm just not good. I'm part of this marriage equality petition. So I really ought not to be talking too much about it, but it's too difficult not to. To see what is happening in court, the deftness with which counsels and arguments are heard. So for instance, he talked about his interests which are beyond. So one young lawyer said, look, I want to file my written submissions and I want to quote Martha Nussbaum, she's a great author. And Justice Chandrachud said, yes, in my spare time, I read Martha Nussbaum. Now, here shows a judge that even in his spare time, he's reading moral philosophy and literature, which is, I think, something most of us would study during court hours to understand something. That is his light reading. So that is the kind of gentleman we are dealing with, that he aims to inform himself constantly about that which is important to learn. And your point on patriarchy is well taken. He's one of the persons. It's a corrosive institution, patriarchy, not only for women, but even for the men within a society. It degenerates everybody. And this is something that Justice Chandrachud is very acutely aware of. And again, since the matter is going on, I can't comment too much on it. But some of his comments on the 30-day notice period under the Special Marriage Act, where he says that if you ask someone to advertise the fact that you're about to get married and you have 30 days to object to it, you're opening up the woman to accusations by the society. You're putting her private life out in the public domain for all to interfere in. And this is nothing but a manifestation of the patriarchal ideas that showed themselves in the law when it was first promulgated in the 19th century.
Thanks to that, I'm going to Senior Advocate Percival Birimoria. Mr. Birimoria, you in your earlier avatar qualified as a chartered accountant, then you turned towards law. So it's natural that you'll do a lot of heavy commercial matters. So when you look at the Rajesh Agarwal judgment, for example, which is mostly, discussed with great admiration by the business community, just welcomed it. And they say that it encourages a pro-business climate in India. What do you feel about such judgments that come out of Justice Chandrachud?
Well, look, I think that is based on the principle of natural justice. So Supreme Court and all our courts, in fact, have always upheld this principle, audi alteram partem. And, that is the right to be heard. And the right to be heard also includes the right to rejoin, to argue a matter. So if somebody has a point which is adversarial to your point, then you have the right to rebut that as well. So it's really a judicial debate. When you say natural justice, somebody has to adjudicate based on a consideration of all facts and circumstances that bear upon the particular decision. And that is something that is being upheld in this judgment, and rightly so, because look, our executive is gargantuan, and many a times I'm not a fan of the executive at all, right? Personally, and many a times, I just pull my hair and say, "Oh my God!" Because if you look at the large number of cases, the commercial cases, most of these cases are essentially a fight against executive overreach. And this is a very good example of one such executive overreach. You can't just, label somebody as a defaulter without, hearing him out. I mean, there has to be some judicial process involved there. But coming back to, the main characteristic of our Chief Justice of India, Saurabh and Abhimanyu mentioned this pretty well. As I said at the very beginning, courageous and progressive. And both these features come out, and also extremely balanced. So, look, when he was appointed as the CJI, a lot of people come around and say, "Oh, is he going to be pro-government or anti-government?" I said, "Don't talk rubbish. I mean, you're talking about the CJI, right?" And of late, the public discourse in this country has really deteriorated to a point where people say, "Oh, is this judge pro-government or anti-government?" There is no such thing. You cannot have any such thing. And when you look at the judgments that are coming out today, you can be rest assured that Justice Chandrachud and, in fact, the entire Supreme Court, because one thing that he has done is really unified the Supreme Court as well. Right? People are on the same page. After all, he's the leader, and people take a cue from the leader. And any decision that is delivered is both correct on points of law as well as fair and balanced. There is no decision that I can think of and wonder whether there is anything here because of which there were some, considerations other than just pure law. And this is the one single characteristic that stands out in all his judgments.
Thank you for your endorsement. In a say, you're saying this libertarian view that he takes is something you like and endorse also. You were saying something.
No, so look, what is libertarian? So libertarian means liberal, right? I was a liberal until long ago, until there are some liberals who started saying that, okay, if you don't agree with me, you can't have this opinion. Right. So this cancel culture that pervades more in Western societies, I'm completely against that. There are people who want to lecture at universities, and students gang up and say, "No, we are not going to hear you." That's not acceptable. But when you look at Justice Chandrachud, he stands for listening to every opinion, every point of view, no matter how radical it may be. You have to take that opinion into consideration and then arrive at the correct view. There may be something there, some grain of truth hidden in what somebody is saying. So these labels like libertarian, are no longer valid, I'm afraid. There is a lot of diffusion between, who's a libertarian, who's a right wing and left wing. Right. So
point well taken. Point well taken. I got what you meant to say. But one theme which you said is, of course, Justice Chandrachud will give you an opportunity to be heard. Whatever your view is, you shall not go unheard. That is the central theme, is what I understand from what you say. I will go to Advocate Abhimanyu Bhandari. Now, Mr. Bhandari, I am a great fan of the Oxford Union debate, which I watch during many times when I get time. You studied at Oxford, where the values of equality, liberty, fraternity, they are all discussed when you did law. These names are taken very loosely in a lot of people who study in law firms without really understanding what they mean. They have such deep meanings because they are embedded into what our democracy is. And when you see a Chief Justice who so passionately speaks about these, we can almost sense when he's speaking that he actually speaks from the heart. He feels what he says. And you know what? One is not able to convey in a manner of speaking. But when somebody is speaking, you understand that he believes in those values. From that standpoint, if you could explore what the tenure of Justice Chandrachud in this 150 days. You're not audible.
Thank you, Tarun. Tarun, it's one thing just speaking. Here we have the Honorable Chief Justice, who not only speaks and professes that everybody, on liberty, on equal rights, on the fact that everybody should get a fair opportunity in our country to participate in an adjudicatory process. But the second thing is that his judgments also speak in the same tenor. So it's not like we have a Chief Justice who speaks very well in a conference, but then there are no judgments that he is giving on either liberty or on passing decisions against the government, where he wants to give a fair opportunity to and uphold the rights of the citizen. You see that all his speeches and everything that he speaks in a conference or in a public debate, you many times see that similar findings in his judgments, where he's protected the rights of the most vulnerable people. Then one started saying that what's happening in the commercial arena? Are there judgments enough where he is going and he's striking down powers of the government where there are false attachments? You spoke about the fraud circular matter on the commercial space, Tarun. That's not the only judgment. There were judgments in GST matters where the court frowned upon the fact that there were certain attachments which were very oppressive and which were completely arbitrary and illegal. And the court immediately set aside those attachments. In commercial matters also, the court is now, one more very great thing is that a number of judgments he's given where he said that just because you have an alternative remedy doesn't mean that you can't come to court under Article 226 to High Court or under Article 32 to the Supreme Court. He has reiterated that no, if a citizen feels that his fundamental right is being breached by the government, he has a right to come directly and knock on the doors of the High Court. He can come even in certain circumstances to the Supreme Court, and he can ask the court to protect his fundamental rights. And that you see in his judgments, not only on the speeches that he makes in conferences and in public debates. Third, Tarun, is even if judgments have the trappings of saying that the court will come and protect your fundamental rights, do people actually get the relief? Is an attachment eventually stayed or quashed? If it's been declared that the fraud circular, does not allow people to be heard before declaring them fraud, is that finding of fraud then set aside against that person? Yes. So the operative part of the judgments also have the relief which come from the main body of the judgment. So here we have a court which is going out of its way to ensure and protect the rights of the citizen. And it starts from day one, Tarun, as I had started by saying, that when you go to court, first thing you want is that your matter should get listed. And we were facing some issues with that, but that's all been streamlined. Second, the fact, as Saurabh said, what the court has done, and this is a great initiative, where English judgments written in English language have been translated into regional languages and uploaded in the ESCR website, where anybody can have access to that without paying any subscription fees. Yes. So you can have people from all parts of the country accessing in their own regional language and understanding. So a judgment like the fraud circular judgment or the right to privacy judgment, one can actually go and access that judgment in the regional language that that person is knows about, and can read that judgment and can appreciate that judgment and realize what his rights are and what his rights are not. So I think that the whole initiative to allow all these judgments, and I think now last I remember is about more than 34,000 judgments have been uploaded in this ESCR platform. So not only we have here a situation where court is giving such judgments, but we also have that those judgments are being uploaded in regional languages so that people are aware about their rights. Because ignorance means there are no rights. Today, if a person comes to know in a remote part of our country that no, this is a right the Supreme Court is upheld in his own regional language, then he will be able to communicate to his people in the village. That communication spreads and people realize that they have certain fundamental rights which the Supreme Court is protecting. Third, Tarun, the way there is emphasis, and this is not a court which is shy of the fact that a lot of the court proceedings are now on YouTube or on social media. And people around the country are watching these proceedings and they're seeing how the court is conducted. This instills a lot of faith in the citizens that the court, although we have an open court system where anybody can walk in, but people don't necessarily walk into the court and people don't feel that the court is a cloistered nun. But for the first time, people are feeling, because people are seeing active deliberations in the court. People are seeing what arguments are being made by counsels in various matters which affect right to privacy, which affect our fundamental right. For example, the matter that is going on and which has caught the attention of the entire country right now. And, when I go back home and I meet my friends who are not in the legal profession, who probably have never read a judgment in their life, are now talking about, oh, this council said this in court and the Chief Justice said this and this is happening. So the country feels that they are participating in this adjudicatory process. The citizens feel they themselves are participating in the adjudicatory process. And that look...
In fact, the constitutional hearings which everybody gets to see.
Everybody gets, and they from all the constitution benches, not only any particular matter.
Abhimanyu, I would like to join voice with you here. A lot of people call me and tell me they are watching the Supreme Court proceedings live and so excited. They say, I was so-and-so advocate, Chief Justice Chandrachud made so-and-so comment, this was said. People are excited, and these are common people, businessmen, chartered accountants. I am surprised they are watching and logging and seeing for these proceedings for hours together. And they say we learn so much. So that is one point I can't help but agree with you. It's completely, he's brought citizens into the fold.
Correct. And Tarun, he has brought the most lawyers from all parts of the country, not connected in the Delhi system, not having uncles and aunties in the system, to look at those videos, see how councils of eminence are arguing, and then log into the VC and find a case which they can present before the court. It is a great moment of joy, because this is, as Saurabh said, he's removing all exclusions. He's allowing people to come and participate in this whole adjudicatory system. And I think this is the great, a great golden era of our judiciary. And along with the Honorable Chief Justice, he's so well supported. The other two top judges in the collegium, Honorable Justice Kaul and Honorable Justice Joseph, the judgments they are giving, their courts also, one can log in and see what is going on. People can participate virtually. So, and recently the Chief Justice said that there's not going to be a day when he's going to allow any vacancy in the Supreme Court. Now, when he sends a message like that out, other high courts and chief justices and other collegiums in various in high courts are listening to this. When he says that we are not going to allow the system of seal cover other than very exceptional circumstances, other high courts are hearing this. Tarun, let me give you an example. The other day, I was arguing a matter in a high court where I've many times, in the financial crime matters, I see there is an urge to present something in a seal cover, and the court said, no, please share a copy with the counsel on the other side. And I just felt at that time that message that the Honorable Chief Justice sent out, transcended to various high court in the minds of various judges, that we have a leader here. We have a captain here who's saying that there will be no seal covers, and we are going to follow that. So that impact that is happening in all over the country is very positive. So, the tide is turning, Tarun, and this, I think, is a golden era of our Supreme Court.
Yeah, thanks for that intervention. Very interesting. We're almost out of time now. So the last word goes to Senior Advocate Saurabh Kirpal, and then we end. Over to you, Mr. Kirpal, for the last word.
Well, another unusual thing about Justice Chandrachud is the sheer length of tenure that he has. It's after some time that we have a Chief Justice who will be there for around 2 years. Of course, nothing to match his father, who was there for 7 years. But 2 years is a very long time. It's also a very crucial time in the polity of our country. We are going into a general election next year. And whoever's Chief Justice at that relevant time when elections are being conducted and shortly thereafter, in our constitutional scheme of things, wields great power. And I have no doubt that the court will be shepherded by Justice Chandrachud. The second judge's, third judge's case all recognize the fact that the court, with its institutional integrity, is really a collegiate system, as Abhimanyu pointed out. And I was recently reading one interview given by Justice Chandrachud, where he said the Supreme Court, one of its failings is that it's a Chief Justice-centric court. And that he hopes, and I have no doubt that he is a man bold enough and strong enough to give up and cede power of the Chief Justice, to ensure that's evenly distributed amongst the entire judges, so that the future of the court, which has to last beyond any incumbent Chief Justice, is secured by the fact that you have able men and women all taking a decision for the betterment of the Constitution and the betterment of the country. But it takes a start. And I think Chief Justice Chandrachud is that one person who will put this court on firm foundations going ahead, not only by the dint of his own strength of character and integrity and intelligence, but also by his generosity and understanding that going forward, we can only go if we all move together.
Point very well taken and nicely summed up. I would like to thank you so much, Senior Advocate Saurabh Kirpal, Senior Advocate Percival Billimoria, Advocate Abhimanyu Bhandari, for finding time, contributing your opinions to this show. I had individually, I enjoyed moderating this session, and there was a great deal of takeaway. I'm sure the viewers would also like to watch this. Appreciate your joining us. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.